This year is the 10th anniversary of the final decision on Kateb versus Godwin and Oars, a landmark case in migration law. The Australian government sought to detain Kateb, a stateless Kuwaiti, indefinitely after refusing his application for asylum. The High Court ruled in favour of Kateb on the basis that indefinite detention of a stateless person is unlawful. Since then, Australian law on statelessness has failed to develop, to the extent that the Australian government has not legislated on a determination procedure for stateless people. Australia does not provide protections under the United Nations Convention on the Status of Stateless Persons, to which Australia is a signatory. This paper analyses sources of Australian country advice KWT 39495 to describe how concepts about stateless communities can develop within the Refugee and Migration Review Tribunals. It challenges the veracity of the country advice information based on the use of its sources. It explains the reasoning behind American and British positions on statelessness in Kuwait in the country advice, which influences determinations on asylum claims in the absence of a procedure to determine and resolve statelessness. It concludes that not only are the country advices in need of update, there is also a need for the quality of the evidence sourced and the interpretation of that evidence to be reviewed. So why does statelessness matter? There are 22 million stateless people worldwide. Most of these people are not displaced refugees but remain in their countries of origin for generations. One of the reasons for this is that if they cross a border from their home country, they will not be allowed back into their home country. The systematic exclusion of stateless people from legal frameworks in their own nations leads some stateless people taking the risk of travelling, and this manifests as asylum flows to adjacent nations and further afield. Stateless, they cannot leave the second country where they arrive, since they have no nation to be exited to. Under Australia's new offshore processing procedures for irregular maritime arrivals, stateless persons who do not make successful claims as refugees are left on Manus Island or Nauru. However, as at May 15, 2012, the Australian Human Rights Commission found that there were 555 people in detention centres around Australia who said that they were stateless, 114 of whom had been detained for over a year and a half, 10 years after the Kateb case had decided that stateless asylum applicants should not be left in indefinite detention. When his case first came to the attention of the Australian media, Ahmed Kateb was a stateless Kuwaiti of Palestinian descent, languishing in indefinite detention in South Australia. The Kuwaiti Bedoon Jinsiya provide a particularly compelling example of statelessness because until 1986 they were treated like citizens in Kuwait, while their claims to human rights and citizenship-like benefits these days are made in competition with more recent arrivals from other regions of the Arab world. A discussion on how the problem developed is beyond the scope of this paper. Suffice to say that the Kuwaiti government has called on the international community to treat this problem as an international issue rather than purely a Kuwaiti issue. Stateless Kuwaitis seek asylum in nations such as Britain, Canada, New Zealand and Australia. The international flow of stateless populations changes the complexions of statelessness in Kuwait and other countries around the world from domestic problems into an international issue, where I discuss Jane McAdams' position paper on a statelessness status determination procedure for Australia. The failure of Australia to implement the convention despite being a signatory is the most significant problem facing stateless people in Australia. This failure means that stateless people have only the UN Convention relating to the status of refugees under which to apply for protection. This means that the most suitable means of protection for stateless people under international law is still denied to stateless people who apply for asylum in Australia, the Convention on the Status of Stateless Persons. This creates a situation where stateless people and their legal counsel are made to fit their circumstances into a case for refugee status, where, according to their circumstances, they may in fact be eligible for protection under the Statelessness Convention in international law and yet be rejected as a refugee. This leads us to a second problem for the failure of stateless people to have their cases resolved in Australian law. The rejection of their asylum claims for refugee status leaves their cases unresolved. Often stateless applicants can't prove they're being persecuted according to the definition in the UN Convention on the Status of Refugees. In Britain, on the other hand, asylum seekers can now apply for refugee status or statelessness according to their needs. Asylum claimants in Australia, on the other hand, have to demonstrate they're being persecuted in a particular way according to the well-founded fear test. If a claim for refugee status is based on membership of a particular group, claimants have to demonstrate that being subjected to persecution, having experienced prejudice or discrimination as members of that group. This means that their asylum cases rely on proof of difference of race, religion, or affiliation upon which claims of persecution are built. Where the status of a person's membership to a group subject to persecution cannot be decided by the tribunal, a person's case is unlikely to be deemed as satisfying the definition of persecution under the Refugee Convention. As a result, it won't be established that that person has a well-founded fear of persecution. Where country advice used by the Australian Refugee and Migration Review Tribunal questions the status of stateless groups who are subjected to persecution according to the group members' sameness or difference, this has the potential to influence individual cases that come before the tribunal. Where claims to identity difference that form the basis of membership to the group and the concomitant persecution are contradicted by claims that group identity is not distinct as it appears in the country advices, this has the potential to impact case outcomes negatively for asylum claimants. Such claims about group identity of stateless Kuwaitis is found in the Australian Country Advice KWT 39495. My paper analyses by close reading the sources of information used in this country advice. The analysis reveals how ideas about the identity of stateless communities subject to persecution appear to have been developed in the Australian Migration Review Tribunal and the Refugee Review Tribunal. It explains the reasoning behind what appears to be two different positions on statelessness in Kuwait expressed in the country advice. The positions relate to stateless Kuwaitis' claims to belonging to a group that is discriminated against or persecuted. I challenge the veracity, quality, and context of American information used in the country advice that was used to assert that stateless people of Kuwait are the same as citizens from Kuwait and that stateless people have no distinct identity or culture compared to citizens. Information in the country advice that was based on British sources were able to assert that stateless people of Kuwait have a distinct identity and a rightful claim to refugee status. The UK source was downplayed despite its better quality and contextual fit for the tribunal. This raises questions about the sources and the interpretation of sources in the advice. The country advices influenced determinations on stateless people's asylum claims in Australia in the absence of a procedure to determine and resolve statelessness, where stateless applicants are expected to prove their refugee status in order to be granted protection by Australian authorities. Australia has had so many Kuwaiti asylum applicants that it began issuing summaries specifically on the Bedoon Jinsiya of Kuwait, those without nationality, to migration department staff via the Australian Country Advice. Numbers of stateless subgroups arriving or staying in Australia are not published by the Department of Immigration and Migration Australia, now the Department of Immigration and Border Protection, nor the Australian Bureau of Statistics, so I cannot tell you just how many applicants there have been. As at mid-2013, however, there were 4 advices listed on the Australian Migration and Refugee Review Tribunal website for stateless Kuwaitis, including Country Advice 37495, 37848, both from 2010, and 38627 and 38642, both from 2011. The advices describe various aspects of Kuwaiti and stateless Kuwaiti issues, including identity, culture, society, and politics. The Country Advice KWT 39495 caught my attention because it discussed claims of identity to the stateless Bidoun Jinsiya that I'm studying at the moment. The 2 main pieces of evidence utilised to describe different viewpoints were about being without Stories of Statelessness in Kuwait by Refugees International 2007 and the UK Home Office Operational Guidance Note Kuwait from March 2009. Regarding the Refugees International source information, Refugees International is a Washington-based advocacy group that produces a number of field reports on statelessness in Kuwait. Regarding the Refugees International source information, Refugees International is a Washington-based advocacy organisation that has produced a number of field reports on the stateless in Kuwait. These include Refugees International from March 5, 2012, May 12, 2012, October 17, 2011, September 2, 2009, and September 12, 2009, and July 25, 2007. Ironically, the publication referenced in the Country Advice is probably the least rigorous research publication on Kuwait that the organisation has produced so far. The document did not even claim to be a fact-based report, but a monograph of stories constructed by a field worker who flew into the site for approximately 2 weeks. While the research method in the Refugees International monograph included interviews to construct a life history of participants, a method used frequently in the qualitative social sciences, the manner in which the author used the data to analyse and construct results was creative, in the creative writing sense, rather than rigorous in an academic sense. The interview data was pieced together to create a general biographical life story. Regarding research on families, only certain individuals in a group were interviewed to provide a portraits of sorts on behalf of the whole family. Principles of beneficence were adhered to by the researcher so loosely in interpreting and reporting the results that I believe that readers would come away from reading the work with a somewhat tainted or negative impression of stateless people. In particular, the author of the Refugees International piece in the Country Advice had relied on sensational language and unverified data to craft his stories on statelessness. Regarding the UK Home Office Operational Guidance Note on Kuwait from March 2009, this was a different piece of evidence altogether. The Operational Guidance Note issued was put together by the Asylum Policy Directorate and drew on a range of information, which included reports from the British Foreign and Commonwealth Office citing humanitarian and diplomatic efforts in the Middle East, Freedom House, another Washington-based rights group whose mandate is quite similar to Refugees International, the US State Department, the National News Service, a Middle East news source, the World Health Organization, and case law from 3 British cases on asylum claims. The sources were authoritative and well spread across a number of genres and included expert testimony, unlike the Refugees International publication. Emerging from the country advice is what looks like 2 different trends, a British position and an American position on statelessness in Kuwait. The Washington-based Refugees International work, the monograph of stories on statelessness, was held out to be comparable to the UK Home Office Operational Guidance Note from 2009 in terms of the evidence from each publication being used to weigh claims of the sameness or distinctiveness of cultural identity of stateless people in Kuwait compared to the citizen population. The monograph of stories was not of a comparable quality to the guidance note, nor did it seem ever intended for the purpose of helping the Australian Refugee or Australian Migration Review Tribunal decide on asylum claims. Other sources used in the country advice included a field report by Refugees International from 2008. Now, this kind of evidence was clearly more suited to being used by the tribunal compared to a monograph of stories. However, the field report was quoted out of context, used to support the argument about the sameness of Kuwaiti stateless people compared to the citizen population, and yet the report clearly described a difference in which the stateless population were marginalised and disadvantaged and discriminated against. On the other hand, the US Department of State information from 2010 was used to support the claim of difference of stateless Kuwaitis. However, it did so by claiming that the stateless community in Kuwait were actually Iraqi. If this line of argument was developed fully, it would substantiate that the stateless in Kuwait are culturally distinct but unwelcome foreigners. Even the Kuwait government acknowledges that stateless people in Kuwait are of Kuwaiti descent. The authors of Country Advice KWT 39495, having elaborated on the Refugees International evidence but not on the British Operational Guidance Note evidence, appeared to favour the American viewpoint that would lead to a negative decision on asylum claims in Australia. Had the Immigration Department checked with the source of the UK Home Office that it claimed did not elaborate further, it would have found that there was in fact ample evidence that refuted the American views expressed in the country advice. In BA and Others from 2004, a case in British immigration law, expert witness Dr. Abbas Shiblak addressed in detail the issue of stateless people in Kuwait comprising Kuwaitis. He soundly refuted the claim, making evidence to the change of composition and numbers of stateless Kuwaitis in the population over time, and he justified a diverse heritage across the region that is shared by Kuwaiti citizens as well. Noting this important contextual information was left out of the country advice, it is not known how the country advices are really constructed, how evidence is evaluated and selected for inclusion. One wonders then why the UK Home Office Operational Guidance Note was not explored more thoroughly when it supported the claims of stateless Kuwaitis to asylum. 10 years on from Kateb, it appears that little has been learned in Australia about the protections that all stateless people are provided under the international law, wherever they are, whoever they are. After an update on country advices was recommended during the 2013 Australian federal election campaign in order to reduce the number of positive Iranian refugee determinations, the Australian country advices on Kuwait were removed from the Australian Migration Review and Refugee Review Tribunal website. There was a message on the website requesting inquiries about the advices to be emailed to the Tribunal. The Tribunal did not respond to my email requesting a copy of the previous advices and a copy of any new advices being used by the Tribunal to be forwarded to me. Despite the success of the Kateb case, which remains a landmark case in Australian migration law, Australia has failed to develop its law on statelessness, and asylum seekers continue to languish in detention or in our community with unresolved cases. There are two main reasons why cases may not be resolved, in my opinion. The first is due to the lack of statelessness implementation procedures with which Australia can apply the protections under the UN Convention relating to the status of stateless persons to which it is a signatory. The second reason, which is explored in this paper, is that stateless person claims for asylum are often unsuccessful under the well-founded fear test according to the definition in the Convention relating to the status of refugees. The Convention relating to the status of stateless persons is designed to address the special context of statelessness under international law, where stateless persons can't access this convention, as is currently the case in Australian law. The applicant and legal counsel are made to fit their case into the alternative convention, making a case for refugee status. The Australian country advices provide information for the Migration Review Tribunal and the Refugee Review Tribunal, which are used to determine refugee claims for all applicants, stateless, refugees, or both. A close reading of Country Advice KWT 39495 on statelessness in Kuwait found two different arguments emerging from the sources that could influence decision-making on asylum claims, where stateless applicants have to apply for protection as refugees in Australia. It was found that not only is there an urgent need for authorities to update and publish the new country advices, there is also a need for the quality of evidence gathered and the interpretation of that evidence to be reviewed. Since writing this paper, the Australian country advices have been removed from the Australian Refugee and Migration Review Tribunal's website. They have not been replaced. One wonders what new advices are being used by the Tribunal, if at all. This is an unsatisfactory situation for Australia's stateless population 10 years after the success of Kateb versus Godwin and Oars.